Hello, I'd like to welcome you to ICANN's webinar entitled 2013 RAA Dealings with Resellers. Today's session will last for approximately 45 minutes and our presenter is Caitlin Tubergen, Registrar Relations and Contracts Manager. Additional ICANN staff is also on hand to help answer any questions that are submitted by you via the Q&A pod, and they will answer as many of them as time permits. Should we run out of time or if you have additional questions after the session, please send them to raaquestions@icann.org. This session is being recorded and links to the presentation materials will be delivered to the registrar mailing list following the webinar. Lastly, I'd like to remind you to mute your computer whilst I hand you over to Caitlin.
Hello, everyone. I'll begin by going over an overview of what we will deal with during this webinar. To begin, we'll have an overview of dealings with resellers under the 2013 RAA. Then we will discuss the definition of reseller in the 2013 RAA and examples of what a reseller is and is not. Next, we will discuss Section 3.12 of the RAA in more detail, and Section 3.12 deals with obligations related to the provision of registrar services related to third parties. Next, we will go over some examples of how registrars can ensure elements in RAA Section 3.12, and last, we will have a time for question and answer. As Haley mentioned, if you would like one of your questions addressed, you can submit a question during any time during the webinar to the Q&A pod, and we will get to as many questions as possible. As many registrars have specifically requested a session dealing with resellers, we will address questions within the scope of this webinar and relating to resellers first. If time permits, we can address questions outside the scope of this webinar. Now we will begin. So some of the highlights of the changes to the interaction with resellers. As you know, reseller is now a defined term in the RAA, and that can be found at Section 1.24 of the agreement. Registrars are now required to maintain written agreements with all of their resellers, and that requirement is found in Section 3.12 of the agreement, and that's a requirement that is required upon signing the agreement. Registrars are now required to enforce their reseller agreements as it relates to the RAA. Under the 2009, registrars were only required to notify resellers when they were keeping the registrar in breach of the agreement, and that is a requirement upon execution of the agreement and can be found in Sections 3.12 and 3.12.6. So up on the screen is the definition of reseller under the 2013 RAA, and it says that a reseller is a person or entity that participates in registrar's distribution channel for domain name registrations, A, pursuant to an agreement, arrangement, or understanding with registrar, or B, with registrar's actual knowledge, provides some or all registrar services, including collecting registration data about registered name holders, submitting the data to registrar, or facilitating the entry of the registration agreement between the registrar and the registered name holder. And as you can see in Section B, registrar services is a defined term or a capitalized term. And that term can be found in Section 1.19 of the RAA. And the registrar services subject to the RAA include contracting with registered name holders, collecting registration data about the registered name holders, and submitting registration information for entry in the registry database. Now we will go over some examples of what may or may not be a reseller under the definition provided in Section 1.24 of the RAA. The first example was raised by several registrars during the outreach sessions or via the RAA questions at ICANN.org queue. So the first example is an attorney who registers a domain name on behalf of its client, and this attorney registers the name from the registrar's public website, has registered only one name in total with your registrar, and pays the price listed on the website for the one domain. In other words, there's no special discount. The attorney is most likely not a reseller under the definition provided in Section 1.24. The second example is a web hosting company that registers a name on behalf of its client. This web hosting company has access to non-public API interface, is given a special discount that is non-exclusive of volume from the registrar, has registered 150,000 domain names on behalf of various clients with your registrar, and has equity in your registrar's company. This web hosting company would be considered a reseller under the definition provided in Section 1.24. The third example is a company that offers domain name registration services and has signed a reseller agreement with your registrar. This company would be considered a reseller under the definition provided in Section 1.24 of the RAA. So these examples are a non-exhaustive list of resellers under the agreement. There are many permutations, and ICANN is unable to give an exhaustive list as we do not run registrar businesses and are unable to come up with any entity that could possibly be a reseller. That being said, registrars should read the definition in Section 1.24 conservatively. Now we're going to look at Section 3.12 of the RAA in more detail. First, we will look at the provisions under Section 3.12 that are required upon signing the agreement. As I stated earlier, Section 3.12 of the RAA provides that registrars must enter into written agreements with all of its resellers. Registrars must ensure that resellers cannot display ICANN or ICANN-accredited registrar logo on their websites, and that's Section 3.12.1 of the RAA. Also, registrars must ensure that any registration agreement used by resellers shall include all registration agreement provisions and notices required by the ICANN RAA and ICANN consensus policies. Additionally, registrars must ensure that its resellers identify the sponsoring registrar upon inquiry from the customer, and that requirement is in Section 3.12.3 of the RAA. And a question that came in from a registrar asked if this provision means that its resellers have to provide a link to the sponsoring registrar on the reseller's website. And the answer to that is no, but if a customer does ask a reseller who the registrar is, the reseller must identify the sponsoring registrar at that time. Additionally, registrars must ensure that its resellers' customers are provided with the link to the ICANN webpage detailing registrant educational information. And that link is provided in subsection 3.16 of the RAA, and I've also included it in the notes section of the Adobe Connect room. Registrars must also ensure that in the event that the registrar learns that a reseller is causing the registrar to be in breach of any provision of the RAA, registrar shall take reasonable steps to enforce its agreement with such reseller so as to cure and prevent further instances of noncompliance. And that can be found in Section 3.12.6 of the RAA, and a little later in the webinar we'll discuss some examples of that. There are a couple of requirements in Section 3.12 that will be enforced beginning the 1st of January of 2014. Those provisions are found in the transition addendum, and they are that registrars must ensure that its resellers comply with the privacy proxy specification and the privacy proxy accreditation program or policy when it's established. So until the privacy or proxy accreditation program or policy is established, registrars must ensure that its resellers are complying with the privacy proxy specification attached to the RAA. And lastly, registrars must ensure that its resellers shall publish on their website and or provide a link to the registrant's benefits and responsibilities specification. And a link to the registrant's benefits and responsibilities specification is provided in the notes section in the Adobe Connect room, and it was also included in a recent announcement that went out to the registrar mailing list. So what does it mean to ensure that your resellers are doing something? On this slide, we provided a few examples of how registrars can ensure. The first is that the registrar can include in all of the reseller obligations in the agreement between your registrar and its resellers and attach consequences for contract noncompliance. Second, the registrar can implement monitoring processes whereby your registrar periodically looks at its resellers' websites to ensure compliance with certain RAA obligations, such as website posting requirements. And the registrar can include annual reporting requirements in the agreement between your registrar and its resellers that will require resellers to provide evidence that they are in compliance with RAA obligations. This is a non-exhaustive list, but we wanted to give registrars some examples that have been vetted with the compliance team and how registrars can ensure the provisions of Section 3.12 of the RAA. So that concludes the presentation portion of this webinar. We will now begin taking questions from the Q&A pod. I wanted to let everyone know that we have some additional members of ICANN staff in the room to help answer questions. We have Tim Cole, the Senior Director of Registrar Relations, Alan Grogan, the Senior Contracting Counsel from the Legal Department, and Owen Smilgalski, the Senior Manager in our Compliance Department. So please submit your questions to the Q&A pod if you have any, and we will read them aloud and answer them. And just to let everyone know, we do have a hard stop at 50 minutes past the hour, so 15:50 UTC.
So this is Alan Grogan. Chris had asked a question about defining shareholder. I think that was used in one of the examples that Caitlin mentioned. I think the important thing to look at is simply to focus on the two elements of the definition of reseller that either participates in the distribution channel pursuant to an agreement, arrangement, or understanding, or with the registrar's actual knowledge provides registrar services. I think the example she gave was simply an example that the reseller could be a shareholder, but that's not a critical portion of the definition. Whether the reseller was a shareholder or not, if it meets either of the other elements, it would fit within the definition of a reseller.
I just wanted to let the participants know that we have unlocked the slides, so if there are any slides that you would like to revisit, you can scroll through them.
Okay, we're going to start with the questions now. The first one is, what are the requirements for a reseller to prove that their customer is the one who signed the registrant agreement?
This is Samantha Eisner, Senior Counsel with ICANN. The reseller obligations, so the registrar needs to maintain views over their resellers to make sure that the resellers are complying with the obligations of the RAA. These are some obligations that the registrars might need to work out in detail with their resellers if they're having their resellers enter into contracts. And so the registrar obligation, and Owen from compliance might have additional details about this, but the registrar obligation is to confirm that there is a registration agreement in place signed by the customer. And so whatever items the reseller needs to put into place, or the registrar needs to make sure the reseller puts into place for that to happen, is what should be done.
Okay, many resellers are not engaged in domain names as their primary business, but are an add-on to other services, e.g. TV or radio commercials. What are registrar requirements to capture retained payment information from reseller transactions like this?
This is Samantha Eisner again. The registrar obligation for maintaining information on payment information that is now included in the data retention specification really requires the registrar, and this would fall down through into their resellers as well, to maintain information or to allow the registrar to get access to information sufficient to show at least some sort of tracking number or transaction number or something to show the source of the payment. So even on the registrar side, it might not be that registrars have exact payment information given how transactions go through or requirements under credit card processing laws, et cetera. And so it would really be the same types of obligations that fall through, that there could be enough information to track the payment, such as a transaction number or those types of things.
Are registrars required to collect and provide to ICANN additional services provided to the end user when the domain registration was ordered?
This is Owen Smigelski. Registrars and resellers are only required to collect information pertaining to registrar services. There's no requirement to retain that information for those additional services to present to ICANN, such as web hosting or search engine optimization or other things. It's certainly something that you can collect, but is not something that needs to be collected or provided to ICANN to the extent that it does not invoke the registrar services.
If the reseller has various websites for their various services, which site should include the relevant links?
This is Alan Grogan again. I think if the reseller has multiple websites and they're offering reseller services on one or more of them, they should have the relevant links on any site on which they're offering any reseller services.
I'm wondering if you can clarify the attorney example. In the example provided, only one domain is being registered by one attorney. What about a group of attorneys registering multiple domains through a registrar on behalf of multiple clients? Technically, they are managing domains on behalf of their clients, but they are not necessarily reselling domains.
This is Caitlin Tubergen. So as I said before, the definition of resellers should be interpreted conservatively. So in the example that you gave, it appears that the attorneys are not resellers, but we would need more facts to actually determine what was going on.
Can we get clarity on the fact that registrars only have visibility as far as the reseller registering the domain when it comes to the data retention specifications? We're struggling to answer this question, so if the person who submitted it could clarify, that would be great. Dave, thank you. I found the examples a little on the extreme end and therefore less than helpful. Can you go into detail a bit on the more in-between cases?
This is Samantha Eisner again. Um, as we were putting together some of the examples, we realized that we were presenting some extreme cases. We've heard throughout the registrar trainings, we've had some of the extreme cases brought up and queried, and so we wanted to address those first. As Caitlin has already indicated, really the in-between cases are will be somewhat case specific, and you know we stand ready to enter into dialogue with the registrars to see how we can possibly get more specific, but this is a situation where it's difficult for ICANN, as we are not the registrars dealing with resellers, to envision all the different types of business relationships that you might have. And so if you have, and you being generally all registrars who are on the call or your colleagues who are not here, have some information about how you yourself identify your registrars or where you think the gray cases may lie, we would like to hear what those are so we can start entering into that dialogue to get a little bit more specific for you on what these definitions, on how the definition applies in the agreement. At this point, though, we urge you to proceed with caution if something doesn't seem to be on one of the clear yes or no paths.
What if the reseller does not have a website?
This is Caitlin Tubergen again. I believe this is referring to the different website posting requirements that registrars are required to ensure that their resellers are keeping. And in the event that a reseller does not operate a website, at a minimum, the posting requirements and the information in the registrant educational materials and registrant benefits and responsibilities specification, for example, need to be provided to the registrant in its registration agreement.
Please confirm that the privacy proxy spec obligations are only relevant for P&P services offered by the registrar and not by any P&P services offered by the reseller or a third party.
This is Alan Grogan again. If you look at the specification on privacy and proxy registrations, it obligates registrar to comply and to require its affiliates and resellers to comply with the spec. So it's not limited just to privacy and proxy services offered directly by the registrar. It would also apply to services offered through resellers.
Why would a reseller need to identify the sponsoring registrar if the obligation is that a registrar has the contract with the registrant?
This is Owen Smigelski again. The simple answer is that that's what the contract requires. And also, it has to be in the Whois output. I'm not sure if there's anything additional with that you need. Please do follow up if I did not answer that.
This is Dave's clarification on his question from earlier. A registrar can only see the transaction between the reseller and the registrar. If, for example, a small IT company buys a domain on behalf of a client through a reseller, the registrar would not know that the small IT company even exists, therefore wouldn't be able to get the financial transaction between the registrant and the small IT company.
This is Samantha Eisner. If we're understanding the question that's been presented, this is asking really about a multiple chain of potential customers. And so here it sounds like there's a reseller who has, or a registrar who has a reseller, and that reseller's customer is a small IT company. And then that small IT company has a customer who it has registered domain name on behalf of. And so if the discussion here is about what the obligation is to capture payment information, at that level it's the obligation to capture payment information between the reseller and the IT company. And it doesn't sound like there's further obligation down the chain. Dave, if we are misinterpreting your question, please write in again. Thank you.
What are the Whois requirements when it comes to a domain submitted by a reseller?
This is Caitlin Tubergen. The requirements for the Whois specification, the Registrar Data Directory Services, and the Whois accuracy verification, those are the same whether the domain is registered with a reseller, through a reseller, or with the registrar directly.
If the service is not affiliated with the registrar, how can it have visibility to the P&P practices of an unaffiliated service?
This is Alan Grogan again. Just to clarify the question, or my answer to the question may have been unclear or ambiguous. For privacy and proxy services that are offered by the registrar but sold through resellers, you'd be obligated to comply with the spec. If those services are offered not by the registrar but are separate services offered by the reseller, the registrar would not be obligated to comply.
Written agreements with all of its resellers. Could this be the reseller acknowledging the reseller agreement online without signature? If this is permitted in the country you operate your registrar in?
This is Samantha Eisner. One of the requirements that we will look for is that there is sufficient documentation that a agreement has been acknowledged, and so I don't think that it's necessary if it's a written agreement or electronically signed agreement, but there should be sufficient detail available to provide information as to the version of the agreement signed, be it electronically or otherwise, and verification or documentation that a signature was provided electronically or otherwise.
This is Owen Smigelski again, and just to clarify, what constitutes a valid agreement is based upon the jurisdiction of the registrar, or could be the reseller, as it may be. So this will vary, and it's not a hard requirement, but it can be some sort of electronic agreement.
If I refer to your example 1, does an attorney IP firm who registered more than one domain name considered as a reseller according to ICANN?
This is Caitlin Tubergen, and again, it would depend on the situation. There could be facts perhaps where this attorney would be a reseller, so we would need more information. But again, just read the definition in 1.24 conservatively.
Section 26 of the Registrar Information Specification. What type of information about the reseller will a registrar be required to provide ICANN, and can you provide an example of a condition upon which ICANN would request such information?
Thank you. This is Samantha Eisner. Under the Registrar Information Specification, it lists out the details of information that the registrar or that the registrar is required to provide regarding its resellers, and it specifically requires a listing of who their resellers are. However, the condition is once that portion goes into operation, ICANN does not need to request the information. There would be a live obligation for the registrars to provide that. We are still working out the details of how often that information would have to be updated with ICANN, because we do understand that for some registrars, their list of resellers changes on a daily basis. We are also working out the operationally inside of ICANN how that reseller information would be stored and the access rights to that information within ICANN. Also, please take note that we have identified in the Registrar Information Specification that certain portions of information can be provided to ICANN designated as confidential, and we would consider those if we were to receive any request, such as a request for documentary information disclosure under the DIDP practice.
Is there a difference between written in 3.12 and paper or electronic 3.7?
This is Alan Grogan. Let us take a look at that and we'll get back to you with an answer following the webinar.
What if your reseller is in a geographical location where they are not allowed to share this payment information of their customer with the registrar?
So this is Samantha Eisner. The obligations of the registrar to collect the information that's specified in the data retention specification fall to the registrar. So that would really be an issue that a registrar would have to consider in entering into reseller relationships.
What if a reseller accepts to the registrar reseller agreement online? Does that suffice the requirement?
This is Owen Smigelski. That would not suffice. There needs to be some sort of record indicating how that acceptance occurred. Examples include recording in the log file the date, the time, the IP address of the individual or the reseller that accepted that. Other alternatives include, if you have to be logged in behind a user password information, you may not necessarily have to log that IP address, but it needs to be enough to show that a valid contract was entered into.
What happens when a domain is sold by a reseller in another country where the reseller's country has privacy laws against disclosing of such information out of the country?
This is Samantha Eisner again. This is a very similar question to what was just posed earlier regarding payment information for resellers. Again, this is the obligations under the Registrar Accreditation Agreement go to the registrar, and the registrar is obligated to make sure that registrations under the RAA, be they performed by the registrar directly or through resellers, are performed in accordance with the RAA. And so this is really something that we encourage registrars to look at more closely.
Surely any information relating to a RAR's reseller are confidential. The RAR should not have to mark something as confidential.
This is Samantha Eisner again. In dealing with ICANN, from many of your registrars' first contact with us when you were applying for a registrar accreditation, there has always been the affirmative obligation on behalf of the registrars or any other party dealing with ICANN to identify information as confidential that is coming into ICANN, because we do try to operate to the extent that we can as most transparently as we can. So there is an affirmative obligation on the registrar to identify items as confidential that they believe are not appropriate for disclosure through our documentary information disclosure policy. And we will have the link to that placed into the chat so everyone can see that. But ICANN does not just presume the confidentiality of information that comes into it.
Most of IP firms do not really understand ICANN rules, and unfortunately, with a reseller definition, they could be considered as reseller since they are collecting registrant data, trademark owner, to register the domain. Such companies should not be considered as reseller.
This is Owen Smigelski again. As we've indicated earlier, the examples provided here were meant to be illustrative and not exhaustive. So it could be possible that scenario which you provide could be considered a reseller. However, this is something that the registrar should look at on a case-by-case basis, and it's also something that compliance would look at on a case-by-case basis. There is also part of the definition does include knowledge by the registrar, so it's not something that would be a compliance matter if the registrar was not aware of that. It's only once the registrar does become aware that somebody would meet that definition that the registrar would have to enter into an agreement with that entity or individual as a reseller.
Regarding a click-through agreement, are there additional requirements for when a reseller selects a click-through versus a registrant?
This is Alan Grogan. I apologize. We're struggling a little bit to understand the question. Maybe you could clarify. Are you asking about the difference between a click-through for a reseller versus a click-through for a registrar? I'm not sure what the question is directed at. I'm sorry.
Okay, we currently have no more questions, but we do have a few more minutes left. So if there's anything else that you'd like to ask, we suggest that you do so now through the Q&A pod. Thank you. Okay, we have one. So will ICANN not accredit registrars in countries that will not allow this information out then?
Thank you. This is Samantha Eisner. I understand this question to be asking, well, I cannot accredit registrars in countries where data protection or privacy laws may pose limitations on information that can be retained or transmitted that is otherwise required on the data retention specification, and that is not the case. ICANN has included within its contracts that there are that it is not requesting or binding registrars to violate their local laws or the applicable laws. In addition, ICANN has recently published a waiver procedure regarding where the provisions of the data retention specification would conflict with the registrar's obligations under applicable law. And so we do have paths forward for registrars who find themselves in those positions.
Would some kind of waiver be applicable to the registrar if he provided ICANN a list that included the type of clients he manages?
This is Alan Grogan. If I understand the question, I mean, ICANN does not intend to provide sort of opinions on who does or doesn't constitute a reseller. Ultimately, that determination would be up to the registrar looking at the terms of the agreement to determine what's required to comply.
Okay, this is a clarification from an earlier question. If my terms already contains the required reseller terms, then is the same click-through I use for registrants adequate to use for the reseller written agreement? I'm based in the US.
Thanks, Tom. This is Samantha Eisner. If you have the required reseller terms in place, then the agreement itself may be adequate for entering into agreements with your resellers. There would be the question of whether or not your resellers are then also providing the required links, and also when it comes to the point where the requirement to provide ICANN with information on your resellers is live, whether you are providing a full list of those resellers. But in terms of the agreement itself, that is likely something that could be sufficient.
Okay, we have a couple of similar questions, so I'm going to let Alan just address them all.
So I think there are several questions that all revolve around compliance with local law and the waiver provisions. And let me try to explain, and hopefully it'll answer several of the questions that have been asked. The waiver, any waiver would need to be applied for by the registrar, but the registrar could apply for a waiver if the registrar believes it's likely to be in violation of law as a result of reseller activities undertaken on the registrar's behalf. So for any situation, whether it's because of activities of the registrar or because of activities of the reseller, if the registrar believes that it requires an exemption from compliance because it would violate local law, the registrar can follow the procedure described in the agreement for providing a written legal opinion and seeking a waiver.
Okay, we have one last question. What type of financial transaction data will registrars be obligated to collect from their resellers, i.e. CC number, amount charged, fail CC number, fraudulent transaction, etc.?
This is Samantha Eisner. We've addressed a similar question earlier in the presentation. It was one of the first questions that came in. The answer to this question is really dependent on the types of information that is available from the resellers. Often registrars themselves couldn't collect the credit card number or failed credit card number, and so we're not seeking to impose a higher obligation on the information that registrars have to obtain from their resellers than the registrars could provide themselves. But really this is looking at the same types of transaction information that a registrar could provide itself, such as a transaction number or other type of trackable information.
There are a couple of additional questions in the Q&A pod, but we have reached the end of this session in terms of time. We did have a hard stop at 1550 UTC. If you would like your questions addressed, you are welcome to submit them to raaquestions@icann.org. There are also 2 upcoming webinars, and you're welcome to ask your questions at those webinars if you would prefer to do it then. I wanted to take a moment to thank all of the ICANN staff that participated in the webinar and helped address questions. Also, thank you for participating, and I hope that you learned something about resellers.
Left.